Kampala, the nation's longest public university. In 1993, she also obtained a diploma in legal practice from the Law Development Center in Kampala, the country's capital city, and was admitted to the Ugandan bar as a practicing lawyer. Then in 2009, she earned a Master's of Business Administration from the Eastern and Southern African Management Institute. Justice Anne expertise in commercial law and tax administration. She practiced law at Miss Mugenyi and Company Advocates until 1996, when she was appointed as a senior legal officer at the Legal Aid Project at the Uganda Law Society. She then joined the Uganda Revenue Authority in 2000 and served as a legal officer in the litigation department, and later elevated to the assistant commissioner at the tax investigation department in 2008 until 2016. She was appointed to the High Court of Uganda as a judge assigned to the commercial division of the High Court till now. So, ladies and gentlemen, please welcome Justice Anne Mugenyi. She's already there. With a clap. Thank you very much. So, this is how we're going to proceed. The main presenter has 15 minutes. The panelists will have 8 minutes. And our main presenter is going to give a general perspective of whatever our topic. And then our panelists will be coming in and giving their own perspective. And after that, we'll open it up for the discussion. So, without further ado, ladies and gentlemen, help me welcome our main presenter, Justice Ochora. Your time. Thank you so very much.
Mero, thank you so much for that nice introduction. Mero, the Chief Justice, brother and sister judges present, distinguished participants, good afternoon. I know we have had a very nice lunch. I'll stick to my 15 minutes. I won't go beyond that. You have the topic for today, or this afternoon, is civil justice reforms, re-engineering business processes in enhancing efficiency in justice delivery. You will agree with me that civil justice systems around the world are facing immense pressure to enhance efficiency, transparency, and accessibility. To surmount these pressures, the concept of business re-engineering processes has emerged to be a robust methodology to achieve the 3 items that I've mentioned. For a class of MPA, business re-engineering processes will be defined as the fundamental rethinking and radical redesign of business processes to enhance performance measures such as speed, cost, service, and etc. But in the context of judicial systems, PPR will speak to what I can call a radical shift from traditional practices of the manner we handle our court processes or our court business to a transformative shift which embraces what I can call a constructed process or processes that achieve efficiency and user-centric systems. There have been various initiatives in various jurisdictions that have been undertaken to achieve efficiency, transparency, and accessibility within judicial systems. And allow me, distinguished participants, to just highlight a few, and I know in the morning much of them have been spoken to. So the first one is leveraging on technology. In justice delivery. Judiciaries, as we had in the morning, should not lag behind in embracing the transformable power of technology to meet the needs of modern society. The integration of advanced technology into our judicial system is the need of the hour to enhance overall efficiency of courts and bring about transparency and also break down geographical barriers that once limited access to justice. A series of transformative technologies or technological initiatives designed to modernize judicial systems have been undertaken by various countries. The first of such initiatives is e-filing systems, whereby filing of documents are done online, and this makes it easier for litigants to file their documents without going to court physically and even filing physical documents. Embracing this reduces the need for physical paperwork, and it speeds up initiation of court processes. The second one of such is online access to case information, digital platforms that provide real-time updates and access to case information, enhance transparency, empower litigants, and minimize unnecessary delays. The third one, which I call a miracle, is virtual hearings, where courts don't need to sit physically. You conduct your hearings, conduct your businesses virtually. For example, in my court, my hearings are 99% virtual. That way, there is enhanced accessibility to court, time is saved, and costs saved for litigants. The other initiative is artificial intelligence applications. AI can be employed to analyze case law and suggest legal precedents, thereby expediting the process of legal research and decision making. And if you want to get the best example where technology has been embraced fully to enhance accessibility to justice, to foster efficiency in justice delivery. The country is Singapore with its integrated case management system. Of course, you can check also on the advanced case management system in the US, where files are digitized. There are automated notifications, and of course, litigants are provided online access for proceedings. The second initiative is what I call a multi-door approach system in the delivery of justice. Put in another way, alternative dispute resolution in our system, justice system. ADR, as we know, it encompasses various mechanisms outside of the traditional court mechanism for dispute resolution. Embrace it well, ADR, like mediation, we mentioned it in the morning, conciliation, and arbitration would lead to faster disposal of matters, and you will agree with me that they are timelier, they are faster than our court processes. By engaging ADR, courts are able to shed off backlog from their shoulders and leave matters that can be resolved outside court process to other mechanisms that the law provide. Appreciating the importance of ADR, some countries have made ADR a constitutional and or statutory imperative. For example, our Article 159 of the Kenyan Constitution commands that in the exercise of judicial authority, courts should appreciate that ADR, like mediation, reconciliation, and traditional mechanisms of dispute resolutions, are important players in the justice system. There are other jurisdictions, like in the UK, where it's mandatory, or there is insistence, that you approach mediation or alternative dispute resolution mechanisms before you approach court for controversy resolution. And how do we ensure that litigants get to those mechanisms that are provided outside the traditional, court system of dispute resolution? Because in the morning you heard that there is resistance, both from advocates and litigants, against engaging these processes. One of the tools, and which is statutory, that can be used is either you refer those matters once they are placed before you to where they belong, or engage the exhaustion doctrine and strike out those matters which are bypassed the forum where they are supposed to be. The third initiative is active case management. And here I can say there has been in various jurisdictions a radical shift from the traditional way of doing business. And now there is an appreciation of the philosophical principle that courts should take interest in cases and their steps throughout their life. And in so doing, courts supervise proceedings. They can sometimes control by giving timelines, and indeed, the pace of proceedings are not left for the litigant to manage, but the court to do. The next initiative, so that we get the country perspectives, is specialized courts. Specialized courts. Court specialization, which in my view is a combination of judge and procedure specialization, is one of those initiatives that can be undertaken within judicial systems to attain efficiency, uniformity, and competence in justice delivery. Specialization of courts indicates the development and functionality of judicial system of a state. It assures qualitative resolution of disputes. And of course, specialized courts serve to reduce and even eliminate conflicts in the interpretation and application of the law in areas of jurisdiction. Uniformity in decision-making leads to certainty, and that the main benefit of certainty is that it reduces the need for litigation and lessens the likelihood that prospective parties will find legitimate grounds for going to court. Kenya has specialized courts that came in courtesy of the new constitution, that is the Environment and Land Court and the Employment and Labor Relations Court. Those two specialized courts, in my estimation, have done a very good job in ensuring that there is efficiency in justice delivery in the areas of their jurisdiction. Of course, if you go South Africa, we have the Labour Court of South Africa, we have the Labour Appeals Court of South Africa, and they have done wonders in creating jurisprudence in their area of jurisdiction. Then the next initiative is usage of tribunals in justice delivery. I know, we all know that tribunals are less expensive, they are less informal, and therefore, in my estimation, easy accessibility to justice through tribunals is assured. If countries go towards that way, coming up with as many as possible tribunals. Kenya has 60 tribunals, 26 have transited into judiciary. Transition into judiciary allows those tribunals to up their capacities in the dispensation of justice. It also allows those tribunals to be independent from the executive, because they cease to be under the ministries where they used to be. Then the next one is judicial performance metrics and accountability. Implementing a transparent system of judicial performance evaluations can enhance accountability and efficiency. Because of this, I woke up very early in the morning. I did 5 certificates of urgency before I came to the conference. Why? Because at the end of the day, at the end of this month, I have to be measured. So the way to go is put judges and judicial officers under performance management. But it must be a well-structured performance management system. Of course, by being under this system, we are accountable to the citizen, the taxpayers who give us our salary. The next, because of time, the next initiative should be implementing compassion training for judicial officers. I'm not saying that sometimes we lack compassion, but sometimes we do when we are discharging our duties. Implementing a comprehensive compassion training program or programs for judicial officers at all levels can significantly enhance the quality and perceived fairness of justice delivery. And here I suggest that such trainings should include trainings on emotional intelligence and cultural sensitivity and understanding social contexts. And of course, since judgment writing is an art, we should keep on getting trained on how we do our judgments. And very lastly, simplified procedures, so that even a layman can access courts or legal forums where disputes can be resolved without facing hurdles of procedures. So, lastly, judicial outreach and public education. Improving public understanding of the legal system or systems can reduce unnecessary litigation and improve compliance with court orders. And this can be actuated by having in place various policies within the justice system that allow public lectures, open court days, and educational programs. In Kenya, sometimes we go to Spice FM to do legal talks, to enlighten Mwananchi on what we do. In conclusion, ladies and gentlemen, civil reforms through business process reengineering present a transformative opportunity for the legal systems of justice delivery. By embracing technology, management, and alternative dispute resolution, we can create a legal environment that puts in priority timely resolution of justice. As we move forward, it is imperative that judges, magistrates, and academia cooperate in implementing these reforms, ensuring that our civil justice system society in the ever-changing landscape. Thank you so much.
Has done a very good job. Has given a general perspective, but even a Kenyan perspective. Another round of applause. Thank you so very much. As I said, we're now going to narrow it down to our countries, and we'll begin with Zanzibar, Rwanda, and lastly, but not least, Uganda. This time we had 8 minutes, but I've been advised that we have 7, and we will decrease to 6 if you don't. So please take it up, Zanzibar. You have 7 minutes to summarize.
Honorable Chief Justice, Justice of Appeals, judges, guests, ladies and gentlemen. I want to share experience from general and Zanzibar in specific, as the only Tanzanian in this group. So I will share experience in Tanzania on reforming civil justice, engineering, and starting with, I want to acknowledge that within the past 10 years in Tanzania, we have witnessed the remarkable changes in electronic filing, which is totally changed the way how the civil files are initiated, processed, they are accessed by judges, attorneys, and other stakeholders in the judiciary. And another changes that we have witnessed is the development and the preparation of rules and guidelines on the key business process, including the High Court Commercial Division, the rules for district magistrates, resident magistrates, and judges, the small claim rules, execution, and other rules which pure are applicable in civil reforms in Tanzania, and Zanzibar is specific. And with this, now in Tanzania, record of cases which are somehow consistent compared with the last 10 years. Another area of reform that I want to touch on is the area of case management that has been addressed before. In this area, now have a case, and now something in our litigation process, the issue of backlog, which has been discussed by the presenter and have been well addressed by the second session today. We have indicators through our Tanzli, Zanli, and other measures issued by the court. Another fundamental reforms is the issue of alternative dispute resolution, which has been enhanced and emphasized in court. Mediation process are well emphasized in commercial division. In Tanzania, commercial division not exceed 14 days. And we have mediation guidelines of 2024, which has been prepared to assist mediation process. However, I have to acknowledge that in this area, we need well-trained mediators and arbitrators the cases before the judges and magistrates. Another area which has been touched by in our presentation is the issue of uniformity and the preparation of report. And now there is a video conference utilization much wider over all the country. And there is also the implementation case management, which is being practiced in many jurisdictions in order to achieve greater judicial efficiency and thereby settle disputes on the merit at appropriate cost. The issue of legal aid is very important, and there are more efforts in place now in Tanzania, in Zanzibar in specific. There are legal aid clinics there, and also there is a mobile court. Now we have witnessed in the welcoming clip which has been shared, which has been issued by the Honorable Chief Justice, and we have seen there the mobile judicial mobile services are also in place. But however, in this area, we need to explore additional ways for legal representative, for specifically in land matters and in family law. In finalizing, I want to share also the area of reform in exploring additional ways in civil litigation process, which include the commitment to provide assistance to vulnerable groups, simplification of forms and rules is very important, and now in Tanzania we have started to simplify our forms, rules in plain language, and we have sort of simple in brochures and other mode of simplified language to assist the people and citizens who are not lawyers, who are not conversant with legal terms, to be aware on the procedures in their civil process. And finally, I want to add the conducting of the perception survey. Now we have conducted different perception survey in Tanzania and Zanzibar, at least to strike balance between independence and procedural predictability. I think now it is time to make assessment for the areas that we found that we have weakness in civil reforms, and to make sure that our judges are well trained and magistrates in re-engineering process in civil reform and in reforming the civil justice in Tanzania. Thank you very much for your attention.
Thank you so very much, Lady Justice Khadija, for even keeping time and giving us a perspective of Zanzibar, but also Tanzania at large. Next is Rwanda. You also have 7 minutes to the dot. Thank you so much. Justice Geraldine, you have the floor.
Thank you, my Lord Chief Justice, Deputy Chief Justices, all judicial officers present. Good afternoon to you all. Thank you, my Lord, for your kind introduction. The experience of Rwanda, I hope you can hear me well. Thank you. Thank you. I'll quickly go through, I think I have 6 minutes now. I'll quickly go through some of the things that the Republic of Rwanda has done to ensure that there is efficiency in the delivery of justice. I will put them in about four or five categories. One is embracing ADR. As a way of speeding the process in the delivery of justice, Rwanda has tried to embrace ADR. So we have embraced mediation. In the area of criminal law, we have started pre-bargaining. And recently, we launched an ADR center. In terms of embracing technology, Rwanda thinks that given the trend of things and the emerging technology, the courts cannot afford to do business as usual. We have no choice but to embrace technology. So what Rwanda has done, we've been talking to you about the, putting together our case management system. We've had this case management system, but I want to tell you two things that are new and that will be actually, there's implementation effective January 1st. We've had a case management system where everything is online, except judgment writing. Well, let me explain this a little bit for you to understand. For example, I'll give you an example quickly of a judge in the Court of Appeal or the Supreme Court. Each one of us has a legal assistant. So when everything is ready, when all parties have submitted their documents, everything is in the court, is in the court system, in an electronic form. The only thing that are not there is that a legal assistant will actually initiate a brief for the judge before you go for a hearing. So she will initiate a brief or a report, and then she will send it to you on your Outlook, on a regular Outlook email for you to consider. And the judge will draft a judgment after the hearing. She actually also, he or she initiates a judgment, a draft judgment. But this has been done outside the electronic case management system. Effective January 1st, judges are now compelled to even to draft their judgment in the electronic case management system. So there is no work effective January that will be done on our Outlook except maybe to say hello, EAMJA, all other court things will be done in the case management system. So effective January, judgment writing, every single decision, everything that every judge does on a case will be e-something, e-decision. There is nothing that is going to be done like in handwriting or on an email, nothing like that. So that is effective January 1st, and we've been trained, and we have another final training before Christmas, and we are set to go. That is Rwanda. Another thing that we are going to do, now we've started engaging with the AI, so we are researching things using AI. Sometime next year, Rwanda wants to teach AI Ikinyarwanda. So AI will be speaking Ikinyarwanda. Thank you. So AI will be using Ikinyarwanda. So that is another level. Effective next year, we are going to have AI telling us things in Kinyarwanda. Whatever, those who can't understand English better or who want to use Kinyarwanda will be using AI in Kinyarwanda. So another thing that Rwanda has done for efficiency is that's embracing ADR and then technology. Another thing that Rwanda has done is to connect all the courts in the judiciary of Rwanda to internet. Even the most remote court is connected. So what the CJ has been now trying to do is to ensure that all courts have fast internet, but otherwise all courts have very, very good internet. Another thing that Rwanda has tried to do is timely law reporting and creation of an online e-portal. So we have judges who say, I don't have a president, I don't know even the updated law, I don't have the updated president. So everything is now, they're going to be feeding the system with everything that is updated so that judges have no excuse in not accessing or complaints of not accessing the most recent judgment. Sometimes some judges say that they don't know which is the most recent precedent, the jurisprudence. So effective January, everything will be set. You have no excuse not to know the most recent judgment. Another thing is that the court set up an anti-corruption committee. I think sometime last year in Uganda, one of our colleagues talked about it. So the anti-corruption committee is for us to ensure you cannot have a corrupt judicial officer and we expect efficiency. So you have to fight corruption in the judiciary of Rwanda, and it's not the responsibility of the CJ, it's the responsibility of all judicial officers in the Rwandan judicial system. Another thing is continuous judicial training for all of us. They have what the judiciary has been trying to do is to ensure
Justice,
that
you have a half a minute to conclude.
each one of us has to be specialized. You cannot just know general things. Each one of us has to have some area of specialization. And lastly, there is something that the former CJ of URT said. It's about strategic leadership, that we cannot wait for the CJs to do everything. His Lordship, Justice Mutabazi, and the past president have been working and are still working on the well-being of the judicial officers. You cannot talk about efficiency in the judiciary in the delivery of justice when you have sickly human resource in the judiciary, when you have starving people. So we have a restaurant. We are very much proud of you, your Lordship, and your team. But one other thing that before he came here, which he did, our president, one other thing that was very, very good, that he has started, him and his team have started engaging judicial officers on the judicial well-being. So some of us have stress because of workload. Some are not eating, have not been eating because we are starving. Some of us have low salaries. So there is a lot of things that go on with a judicial officer, depression, stress, and all that. So they have now started talking to us, and they bring experts, and we are starting to open up, to engage each other so that we can relieve stress. So thank you so much, and I hope you can chip in.
Thank you very much, Lady Justice. I added her a minute because she was talking about MISO, and there was corruption in this. Thank you very much. Thank you, Lady Justice Geraldine. Now, ladies and gentlemen, we are going to hear from Uganda, the perspective of Uganda. If you can, Lady Justice, in 7 minutes, we will be happy, and thank you so much.
Thank you, my Lord. Good afternoon, the Honorable Chief Justices, the Deputy Chief Justice of Uganda, Justice Butera, all distinguished justices and judges of the courts of judicature, your worships, and all distinguished guests. I had prepared a PowerPoint, but I've been asked to reduce it in 2 points within 7 minutes, so that's what I'm going to try and do. Re-engineering business processes to enhance efficiency in justice delivery, the Ugandan judiciary perspective. The Ugandan judiciary has done a lot of process engineering, and I'll point out about 9 of the areas: case management systems, alternative dispute resolution, court infrastructure and technology, judicial training and capacity building, legal framework and policies, public awareness and access to justice, data analytics, collaboration and stakeholder engagements. I'm going to go quickly through this so that I can fit within the 7 minutes. In 2022, the Ugandan judiciary introduced an automated case tracking system called ECMIS. The system has been It has been systematically rolled out in different courts to facilitate the electronic management of cases, right from case filing up to the final disposal of cases. The system has also enabled the tracking of cases from the filing stage until the conclusion. This innovation has facilitated a reduction in delays associated with case handling, scheduling and calendaring, and general facilities, and facilitates a paperless case disposal process. There are timely updates, which is case management, and reduce on instances of unnecessary adjournments and preparedness of counsel and litigants, thereby time saving in the long run. The Ugandan judiciary also operates the CAS system, from which the ECMIS system was upgraded. We have a case management committee which was established by the Administration of Judiciary Establishment of Committees Regulations. This committee is chaired by the Deputy Chief Justice here with us, and it's responsible for studying the challenges to effective delivery of justice and advising on appropriate strategies to address the challenges, conducting research, consultations, and benchmarking with a view to establishing best practices and policies on alternative dispute resolution, case backlog clearance, and case management for the judiciary, and advising the Chief Justice on performance enhancement strategies across the courts. We have also embraced alternative dispute resolution. Mediation has been revamped in Uganda, and retired judges and distinguished members of society have been brought on board to facilitate the mediation process as court annex mediators. The mediation rules are also being reviewed to enable mediation to take place in a more efficient and productive manner. There's training ongoing for mediation and ADR professionals. We also embraced arbitration. We had a case settlement week, which was designated for mediators in the different courts of law. Judges are actively involved in mediation as well and have dedicated days for active participation in the same. This enables swift resolution of disputes and also maintains relationships between the parties, among other advantages. Court infrastructure and technology, we've already talked about ECMIS, which enables us to have our e-filing systems and electronic filing of documents, reducing paperwork and making work more efficient. We have audio and visual conferencing systems. Most of our courtrooms, especially in the commercial court, are all fitted with this video conferencing for hearings, and this saves time and reduces the need for physical presence and necessary adjournments that delay trials. We have real-time transcription of court proceedings. The judiciary is invested in training transcribers in real-time transcription. Once this is rolled out, it will enable speedy transcription and readily available record of proceedings. Ongoing is the development of a judgment writing tool, which will aid judicial officers in the process of judgment writing and will guarantee the standard of judgments as well as enhance the speed of time within which they are delivered. We have the judiciary has taken on court infrastructure. Quite a number of courts have been constructed. For example, the Supreme Court, the Court of Appeal, as well as Chief Magistrates court buildings countrywide. There's also been renovation of old court buildings so that the courts are operational in the different parts of the country, thereby enabling access to justice to our people. Judicial training and capacity building, we have a Judicial Training Institute which was established in 2004. And this is responsible for training. We have access to reference materials. We have the Uganda Legal Information Institute, where judgments and all the different laws are posted for easy access by the judicial officers. Legal framework and policies, there are many that have been reviewed and updated to enhance efficiency and administration of justice. These include the Judicature Amendment Act, the Magistrates Courts Amendment Bill, the Judicature Management of Exhibits Practice Directions, and many others. There are many policies that have been adopted by the judiciary to promote efficiency and mechanisms for handling case backlog, plea bargain, daily hearing of criminal cases, small claims procedure, inspectorate of courts. The judiciary has also undertaken public awareness about court processes. On 15th April 2024, the judiciary held its first ever National Court Open Day under the theme, A People-Centered Approach to Justice. This marked a significant milestone in its commitment to bringing justice closer to the people. We have court open days where we open up and members of the public are able to come and learn about our processes. State provision of legal aid services, justice centers, the Judiciary States Brief Scheme, community-based legal aid, local council courts,
Justice, you have half a minute.
Okay, I'm also ending. The Legal Aid Project of Uganda Law Society. All these are policies and activities that are put in place to enable access to justice. We have data analytics. The performance of courts is based on case data and statistics collected monthly, quarterly, and annually. These statistics are aligned to the judiciary strategic plan, and the performance of courts is broken down so we can be able to tell cases brought